Mr. Cooper, I'm ready to proceed. Are you ready now? I asked you a few questions and you told I let you have until 2 o'clock to provide answers, and I'm looking forward to hearing from you.
I'm not as prepared as I'd like to be with the answers, sir. The last that we checked in with our client, he was on the way to appear before a physician. We haven't been able to connect with him since that time, and therefore I'm not able to update you of the circumstances. I do want to query from before the break, you were going to provide us, Mr. LaPrairie, or somebody on your behalf, with the names of the interpreters other than their surnames. I don't know that we've received that yet.
Well, we should deal with the first issue. I submit, Mr. Barclay.
Mr. Cooper, I have now considered your request, and it appears that Mr. Norn's non-appearance and allegations of an emergent medical condition is not supported to date by any evidence that you have submitted, and leads me to the inescapable conclusion that this is a further delaying tactic that I will not countenance. It is clear from all the background of these proceedings that Mr. Norn is not only well aware of all the issues, but did take part in giving you instructions on a series of very, very complex matters. By way of example, on September the 2nd, Mr. Norn appeared before me and participated in a very complex legal argument involving allegations of institutional bias. And very recently, on September the 22nd, he was examined by my counsel under oath for 1.5 hours and answered a series of questions, many of which were very complex. Also, over the course of 2.5 months, you wrote approximately 19 letters demanding matters which he would have had to give you instructions. These included multiple requests to delay these proceedings, including attempts to have my counsel disqualified and have me removed. Mr. Cooper, you have made repeated allegations that this inquiry is tainted by conflict of interest and institutional bias. Due to allegations, there was a toxic atmosphere in the Legislative Assembly and the clerk's office. These alleged incidents predated the complaint of Mr. Norn. In support of Mr. Cooper's application to stay the proceedings on the basis of institutional bias, an application for subpoenas was made to me. They included the clerk and acting deputy clerk, Glenn Rutland, member Rylund Johnson, the Speaker and members of the Board of Management of the Legislative Assembly, and a series of affidavits and briefs were filed, including a very, very lengthy affidavit by Mr. Norn in support of the application. I issued a lengthy judgment concluding that I did not have jurisdiction to issue subpoenas as the allegations were unrelated to the terms of reference. I now feel that all of this leads me to the inescapable conclusion that Mr. Norn's non-appearance is simply a further delay tactic that I will not countenance. This inquiry will now proceed. And I have a few opening comments, and then I'm going to turn it over to my counsel, Mr. LaPrairie. I was going to say good morning, but it's now good afternoon. I wish to introduce myself. My name is Ronald Barclay, and I've been appointed as the sole adjudicator by the Speaker of the Northwest Territories Legislative Assembly on the recommendation of the Board of Management of the Assembly. The title Sole Adjudicator is a fancy title for the word judge, and judging will be my mandate in this inquiry. This inquiry arose out of the complaint that was filed by Mr. Rylund Johnson, a member of the Legislative Assembly for Yellowknife North, at the direction of the members of the Legislative Caucus, alleging that certain actions of Mr. Steve Norn, member of the Legislative Assembly for the Northwest Territories, were in violation of the member's code of conduct by breaching the mandatory period of self-isolation for COVID-19 in the Northwest Territories. The complaint was made to David Jones, QC, the Integrity Commissioner for the Northwest Territories. Mr. Jones was of the view that the public interest dictated that this matter proceed to an inquiry. In conclusion, in his report, he stated, leaving self-isolation prior to the required 14 days is not a trivial or minor matter. The public health order was mandatory, and the self-isolation requirement was well known. Mr. Norn knew about it as evidenced by his filing of his self-isolation plan. Going to the Legislative Assembly on April the 17th was a major deviation from his obligation to stay isolated at his home for the required 14 days. So was his going to the racquet club the following day, April the 18th, which was still within the self-isolation period. Neither of these was a case of going a few meters outside of his home lot, which might perhaps be considered a minor infraction. Similarly, neither of these breaches he was committed through inadvertence. Both breaches of the self-isolation requirement were intentional. And I'm still reading from Mr. Jones' report. And this is what he finally concludes. With respect to making an error in judgment in good faith, even if Mr. Norn made an error in thinking that the self-isolation period included all of April the 4th, the date he crossed the Alberta Northwest Territories border late in the afternoon or early in the evening, so that April the 17th would have been the last day of his required self-isolation. He nevertheless went to the Legislative Assembly on April the 17th, when he was still required to be isolated at home. That is not simply an error of judgment. And that's really the end of Mr. Jones' report. Now, I'm going to do something a little unusual because I don't have any relationship with the bar or members of the Legislative Assembly in the Northwest Territories and the public. I'm going to briefly go through my legal experience because I think the bar, members of the Legislative Assembly, and the public are entitled to know a little about who's judging this case. It's a very grave responsibility to conduct such an inquiry, and I thought you're entitled, therefore, to some knowledge about my experience and career. After graduating from high school at the University of Saskatchewan and spending a period as a Crown prosecutor in Regina, I became associated with and then a partner in Saskatchewan's largest law firm, McPherson, Leslie and Tyerman. And the last few years when I was in the firm, I was the head of the litigation department. When I retired from the firm, I was a senior partner specializing in civil litigation. During my practice, I was a very familiar figure in all of the courts in Saskatchewan, and I've also had numerous appearances in the Supreme Court of Canada. After my 20 years at McPherson, Leslie and Tyerman, I was appointed to the Saskatchewan Court of Queen's Bench, where I served for 26 years. During that time, I authorized over 500 judgments. After I retired from the bench at the request of Premier Brad Wall of Saskatchewan, I served as the Conflict of Interest Commissioner for the Saskatchewan Legislature for a period of 10 years. And during my sojourn as Commissioner, I acquired a tremendous amount of respect for the politicians and the service they rendered to the legislature and the community. While I was a justice, I served as national president of the Canadian Superior Court Judges Association, and that gives me one little connection with the Northwest Territories, as I characterize him as the dean of the bar in Yellowknife, John Vertes, who went on to become a very well-known and prominent judge in Yellowknife. He followed me as the president, and we've become very close social friends, and I see him from time to time. I was then appointed by the Chief Justice as chair of the Federal Judicial Advisory Committee for Saskatchewan, and their mandate is to approve candidates for federal judicial appointments, and I did that up until my retirement. And latterly, I was also the Saskatchewan representative to the National Committee for Judicial Ethics for federal court judges. And as a after I retired as a jurist, I received two prestigious awards, and one was an honorary life membership in the Saskatchewan Trial Lawyers Association, and the other one was the Canadian Bar Association's Distinguished Service Award. Now, after my retirement, I presided over numerous arbitration hearings, but more particularly, several judicial inquiries, and my counsel on each case was this gentleman that's sitting beside me, my counsel, Morris LaPrairie. So I think the two of us, with our experience, will try and ensure that Mr. Norn has a fair trial. Now, I'm going to just spend a little time, because I think particularly the public and even some lawyers don't know what a commission counsel does. You can walk in the room and Mr. LaPrairie and I are consulting and maybe have a fast adjournment and go into another room and discuss the issues. He's not a prosecutor. He's my counsel. And as the learned law professor and author Ed Ritushny states, commission counsel is in effect an extension of the commissioner. Commissioner Dennis O'Connor, former Associate Chief Justice of the Ontario Court of Appeal, who presided over the Walkerton and RR inquiries, authored an article entitled The Role of a Commission Counsel in a Public Inquiry. In this article, he summarized the conduct of public inquiries, and he stated the role of commission counsel is as follows. 1, to provide advice and guidance to the commissioner throughout the process. This includes acting as a sounding board. 2, to supervise and conduct the investigation into all of the information relevant to the terms of reference, including gathering documentation and interviewing witnesses. 3, to develop and maintain open communication with all parties and to encourage cooperation in facilitating the disclosure and presentation of evidence. 4, to call evidence at the hearing, including witnesses the parties seek to call. Cross-examination by the parties is likely to be limited if the prior examination by commission counsel has been thorough and fair. And to serve as the media spokesman for the commission to the media. Commission counsel also has that very close relationship to the commissioner, and this was focused in Commissioner O'Connor's article. He concluded that it is with the commission counsel that the commissioner carries out his or her mandate, investing in the subject matter of the inquiry, leading evidence, and throughout, he acts on behalf of the commissioner. As the very learned Professor Ed Ritushny stated, impartiality on the part of commission counsel is not to be confused with a lack of vigor and diligence in seeking the truth. Commission counsel must still act forcibly whenever necessary to overcome resistance that could obscure truth. This persistence is particularly important wherever the transparency of the public inquiries motivates resistance on the part of those with something to hide. What makes commission counsel role unique is that they must take into consideration the public interest, the interests of all the parties, and furthermore must explore conscientiously all plausible explanations and outcomes, regardless of whose interests are advanced. We now have reached a point in the evolution of commission counsel's role where it can be confidentially asserted that every task they undertake must be infused with partiality inseparable in degree from that of the commissioner. It is also an honor now for me to introduce learned counsel for Mr. Norn, and I'm looking for assistance throughout these hearings at Stephen Cooper and his associate, Ronald Hullaby. I'm going to say this, although Mr. Norn is not here right at this moment, that the most critical, and I'm going to emphasize this, of my mandate is to ensure that Mr. Norn has a fair hearing before me, and I will assure you and undertake that that will happen. I'm very disappointed as my counsel that we are unable to personally attend in Yellowknife to conduct this inquiry. We were all looking forward to it. However, in view of the pandemic, we must be guided by the Speaker's recommendation. The Speaker's position is as follows. While parliamentary privilege would allow the inquiry to continue as an in-person event, the Speaker is concerned about the public reaction to the hearing taking place in person, including several people traveling in from southern Canada, when the subject of the hearing is whether or not public health orders were followed. As a result, the Speaker is recommending that the hearing take place as a blended virtual in-person hearing. And I must compliment everybody that's involved in putting this together. Everything is just working so well. The audio, I can see everybody clearly, and I'm assuming that will continue throughout the hearing. The Speaker will continue to make Committee Room A available for the clerk to the inquiry, Mr. Norn, his counsel, and witnesses, although Mr. Cooper is in his office in Edmonton. We can provide a room-to-room video conference hookup for counsel to the inquiry. And we're already doing this, but we'll be able to broadcast the proceedings as originally planned. There were also restrictions in the territorial courts and civil and family court in Yellowknife, as all appearances are now being conducted by teleconference. Therefore, we are going to proceed as recommended by the Speaker. Now, I'm just a few words about what my powers are, and then I will conclude. But as the sole adjudicator, I don't like that phrase very much, but that's what's in the Act, under the Legislative Assembly and Executive Council Act of the Northwest Territories, my mandate firstly is to conduct this inquiry. And at the conclusion of the inquiry, I have the power to dismiss the complaint, and that will be the end of it if I dismiss the complaint, or in the alternative, find the member guilty of contravening provisions of the Act or the Code. If I find that the complaint has been proven, then I have further powers as to penalty. However, it is critical to underscore that I only have power to make recommendations to the Legislative Assembly, as the Assembly under the British parliamentary system is the court. They can either accept or reject my recommendations. The legislature authorizes me as sole adjudicator to make the following recommendations. 1, to reprimand the member. 2, impose a fine of not exceeding $25,000. 3, make an order for restitution or pay compensation for any loss. 4, make an order suspending the member for a period not exceeding 30 days, or laterally make an order declaring the seat vacant. And those are my powers, but they're only recommendations. It's the Legislative Assembly that makes the final decision. I'm now going to call on the Commission Counsel, Mr. Morris LaPrairie QC, to say a few words with respect to how this inquiry will proceed.
Thank you, Mr. Barclay. I only have a number of housekeeping matters that I want to point out before we proceed with the evidence. This is a public hearing, a public broadcast via live stream on YouTube. There are portions of the hearing that may not be public upon the discretion of Mr. Barclay, and for those portions, the only people who will be present are those that Mr. Barclay designates as being allowed to attend. There will be numerous documents that will be presented to Mr. Barclay and entered as exhibits before him. These documents will not be displayed on the broadcast. The witnesses are going to be examined and cross-examined by their counsel. We are pleased to be joined today by our court clerk, Sheila Anderson, and we welcome her. We will be joined by video link, and already have been, by Mr. Cooper and Mr. Halaba, and hopefully Mr. Norn. We have a court reporter today, Jenna Mearns, and Jenna will be creating a transcript that will be available only to Commission Counsel, the adjudicator, and Mr. Norn and his counsel, and no one else. Our scheduled times, proposed times for the hearing would be from 10 to 12:30, 2 to 5 today, and subsequently we'll be doing it from hopefully 9:30 to 12:30, 2 to 5, with a short break as directed by Mr. Barclay, the sole adjudicator, as he desires for health reasons or otherwise. The exhibits will all be marked by Sheila Anderson, who is present in the... Is it okay? Okay. We're just going to... Sheila? Lost her. Okay. We've lost our link. We need to turn it back on. There. All right, have we resumed? Are you able to hear us? Sheila?
Yes, we're able to hear you here, yes. We never lost you.
Okay, I'm sorry. We had a power failure here, a very brief one, I think. I apologize for that. And I'll just continue then. The exhibits will be marked by Sheila Anderson, and she will swear or affirm all witnesses. I will be saying something about the persons who may have applied for standing. We did advertise for anyone who had, wanted to have standing to appear, and I will be referring to our advertising in that regard. But however, no one has indicated that they wish to have standing and be heard pursuant to the advertisement that I'll mark in a minute. There are rules that apply to this proceeding. Mr. Cooper and Mr. Halaba will be familiar with them, and I'll be marking them shortly. All of the exhibits that we'll be marking today have been provided in advance. Sheila Anderson has a copy of them, and of course, Mr. Cooper and Mr. Halaba and Mr. Norn have also been given hard copies as well as electronic copies of those exhibits. As I mentioned, there's a simultaneous translation to and from Chipewyan being provided by our translators, who, by the way, their full names are Dennis Drygeese and Tom Unka, A-U-N-K-A. but I want to make a correction to what I said this morning in terms of the public viewing of the proceedings in Chipewyan. This will be available only at the end of each day. The interpretation that is simultaneous for the participants, including Mr. Norn, Mr. Cooper, Mr. Aliba, is accessible by the Zoom link interpretation drop-down menu. But for those watching this by way of YouTube public broadcasting, that interpretation is being recorded and then posted on YouTube with the simultaneous interpretation available for participants who wish, for individuals who wish to view that YouTube video. For those who want to watch it in Chipewyan, they will need to wait until the end of each day is over and then watch. I'm informed that this is how the Legislative Assembly has been dealing with the session broadcasts, and it is a standard practice of the legislature. Now, I would like Mr. Barclay to proceed with the marking of the first few foundational exhibits, if I might.
You go right ahead.
The first exhibit I ask to be entered before you, Mr. Barclay, is exhibit number 1. And this, Mr. Barclay, is a resolution of the House of the Northwest Territories Legislative Assembly, a resolution of June the 5th, 2014, being resolution 23-17-5, in which you are appointed amongst a panel of sole adjudicators. It reads, motion, appointment of sole adjudicators. Whereas Section 103 of the Legislative Assembly and Executive Council Act provides for the approval of sole adjudicators by motion of this House, and whereas it is desirable to have persons approved for appointment as sole adjudicators for conflict of interest matters under Section 103 of the Legislative Assembly and Executive Council Act. Now, therefore, I move, seconded by the Honourable Member for Montpuy, that the following persons be approved by the Legislative Assembly as sole adjudicators. 1, Honourable R.L. Barclay. 2, Mr. Paul D. Fraser. 3, Mr. Ronald Perozzo. 4, Honourable G.E. Ted Richard and the Honourable Martina Trussler. And so I ask that that motion of the House be marked as the first exhibit, Mr. Barclay.
So marked.
Exhibit 1. Exhibit 2. I place before you, Mr. Barclay, a letter from Colette Langlois, acting clerk of the Legislative Assembly, as she was then, on June the 6th, 2014, addressed to the Honourable Ronald L. Barclay, QC. The letter reads, appointment as approved sole adjudicator. Paragraph. I am pleased to advise you that the Legislative Assembly has approved you for appointment as a sole adjudicator for conflict of interest inquiries, effective June 5th, 2014. A copy of the formal resolution is attached. There is no further action needed at this time. Should a matter arise in respect of which the Conflict of Interest Commissioner directs an inquiry before a sole adjudicator, the clerk would contact you to determine your availability to act in the matter. Following that, the Board of Management would recommend an appointment from among the available approved sole adjudicators to conduct the inquiry, and we would negotiate a fees arrangement with the appointee at that time. Paragraph. On behalf of the Legislative Assembly, I would like to thank you very much for putting your name forward. Although we hope never to have to call on your services, it is essential that we be prepared in the event of the need for an inquiry, and your willingness to be included on our list of approved sole adjudicators is very much appreciated. Paragraph. Please do not hesitate to contact me should you have any questions. Signed, Colette Langlois, Acting Clerk of the Legislative Assembly. I tender that as Exhibit 2, Mr. Barclay. Mr. Barclay, Exhibit 3, I propose the complaint that's made in herein by Rylund Johnson, which was received on May the 6th, 2021 by the Integrity Commissioner, Mr. David Jones. The complaint, I will read a portion of it only, but it starts as follows. Mr. David P. Jones, QC, Integrity Commissioner. Quote, caucus is where all 19 members of the Legislative Assembly meet as equals, free of normal position, to set broad strategic direction for a Legislative Assembly and discuss matters of widespread importance to the Northwest Territories as they arise. Caucus is intended to provide a venue where members can share their views freely and confidentially without those comments being repeated or disclosed. Paragraph. Further, pursuant to the consensus government process conventions, caucus mandate includes the Code of Conduct for members of the Northwest Territories Legislative Assembly, bracket, the Code of Conduct, end of bracket, and discipline for members. Paragraph. It is important to note that caucus is not a decision-making body, but can provide direction. In this case, caucus has directed that I, the caucus chair, file a complaint with you against Mr. Steve Norn, the MLA for Tuna Williday for breaches of the Code of Conduct. In filing this complaint, I have used publicly available information. I have not disclosed caucus discussions. Paragraph. It is alleged that Mr. Norn breached the following sections of the Code of Conduct. Section 2, members must act lawfully in a manner that will withstand the closest public scrutiny, upholding the integrity and honor of the Legislative Assembly and its members. Members shall ensure their conduct does not bring the integrity of their office or the Legislative Assembly into disrepute. Section 4, members must carry out their official duties objectively and without consideration of personal or financial interests, and must arrange their personal affairs so as to maintain the trust and confidence of the public. Section 8 of the Code. The Code is not designed to be exhaustive, and there will be occasions on which members will find it necessary to adopt more stringent standards of conduct in order to protect the public interest and to enhance public confidence and trust. It is alleged that Mr. Norn breached the Code of Conduct by allegation 1, breaching section 2A and D of the Public Health Order COVID-19 travel restrictions and self-isolation protocol as amended December 1st, 2020, which is the self-isolation order by 1, failing to self-isolate for 14 days in accordance with the self-isolation requirements set out in Appendix A of the order, and 2, by failing to comply with the self-isolation plan. Allegation 2, misleading the public regarding his compliance with the self-isolation order. Then Mr. Johnson, Rylund Johnson, goes into the circumstances of the 2 allegations, which I will not read into the record. They will be subject of evidence before you today, in the days to come, today and the days to come. So I would submit that the complaint that was initially made to Mr. David P. Jones, which ended with his report, which I will mark in a minute, be marked as the next exhibit.
It'll be so marked.
Exhibit 3.
Well, that's a 3, yep. Exhibit 3 is a complaint.
The next exhibit is 4. I tender before you, Mr. Barclay, the report prepared by and submitted to the legislature by David Jones on June the 14th, 2021. You have read a portion of that before.
I read the conclusion, yes.
Right. This entire report is available on the legislative website, but I will only read for you the conclusion, which gives you jurisdiction to deal with this matter today. I'm referring specifically to his note, which reads as follows. Next steps. This is at page 13 of his report. Next steps. I am sending a copy of this report to Mr. Norn via his legal counsel and to Mr. Johnson. And Mr. Johnson was the complainant. Quoting, Section 102(2) of the Act provides the Speaker will deliver a copy of this report to each member of the Legislative Assembly and to the Clerk. Section 102(4) requires the Speaker to lay a copy of this report before the Legislative Assembly at the earliest opportunity. Pursuant to Section 103(2), the Board of Management will recommend to the Commissioner of the Northwest Territories that they appoint a sole adjudicator from the list of names which the Legislative Assembly has previously approved, pursuant to Section 103, signed David Philip Jones, QC, Northwest Territory Integrity Commissioner, June 14th, 2021. I ask that that be marked as the next exhibit.
It'll be so marked.
Exhibit 4. Exhibit 5. On July 21st, 2021, pursuant to Section 109 of the Legislative Assembly Council Act, that's 109 sub 2 sub B, I wrote to David P. Jones as your counsel this letter, which appears at proposed exhibit tab 5. Mr. Jones, quote, on June 28th, the Honourable Frederick Blake, Jr., Speaker of the Northwest Territories Legislative Assembly, appointed the Honourable Ronald Barclay as the sole adjudicator for an inquiry into a complaint made by Rylund Johnson, MLA, for Yellowknife North, alleging that Mr. Steve Norn, MLA, for Tuna-Widley, breached the member's code of conduct. The letter of appointment is attached here too. Paragraph, the terms of reference for the inquiry were established on July 8, 2021 and are attached. Paragraph, the rules of practice and procedure for the inquiry were established on June 14, 2021 and are attached. Paragraph, on July 14, 2021, Mr. Barclay engaged me as counsel to the inquiry. The engaged letter is attached. Paragraph, while the date of the inquiry has yet to be fixed, we have begun gathering relevant documents for the inquiry. Pursuant to the power granted by Section 105 of the Legislative Assembly and Executive Council Act to compel any document relevance to the inquiry, we seek to acquire all of the documents that you obtained in the course of your investigation and report, including the following. 1, all written communication with Mr. Norn or his counsel. 2, Mr. Norn's response to the complaint. 3, any other relevant factual documents or communications that were utilized in the course of your investigation and not included as attachments to your report. Paragraph, our understanding is that these documents can be made available as per Section 109(2)(b) of the Act, which states that information which would normally be held confidential by the Integrity Commissioner under subsection 1 may be disclosed for the purposes of conducting an inquiry. If you prefer, we will also provide you with a subpoena pursuant to Rule 18 of the Rules of Practice and Procedure in order to obtain these documents. Please advise, and we shall act accordingly. Mr. Barclay, in response to that, I advise you that I received by letter July 22nd, which appears at proposed tab 5, exhibit 5, a letter addressed to me from David Philip Jones, QC Integrity Commissioner. Paragraph, I am responding to your letter of July 21st, 2021 as provided for in Section 109(2)(b) of the S.N.W.T Legislative Assembly and Executive Council Act. You have my reports to the Speaker dated June 14th, 2021, which contains, and then he lists the appendix to his report, which I won't read. In addition, I'm attaching the following correspondence. 1, my letter dated May 7th, 2021 to Mr. Norn. 2, my letter dated May 13th, 2021 to Mr. Norn. 3, letter dated May 14th, 2021, received from Mr. Norn's legal counsel, Stephen Cooper, requesting an extension for Mr. Norn's response to the complaint. 3, my letter dated May 14th, 2021 to Mr. Norn's legal counsel, granting the extension for this response. 5, letter dated May 28th, 21, received from Mr. Halava, a lawyer in Mr. Cooper's office, requesting a further extension for the response. 6, my letter dated May 28th, 2021, granting the further extension to June 7th, 2021. 7, letter dated June 7th, 2021 from Stephen Cooper providing Mr. Norn's response to the complaint. Paragraph, I did not utilize any other factual documents or communication in the course of my investigation into the complaint. Paragraph, please let me know if you or the sole adjudicator require anything further. I asked Mr. Barclay that my letter of July 21st, 2021 and Mr. Jones's response letter of July 22nd, 2021, along with all attachments, be marked as Exhibit 5.
Submission with respect to this particular exhibit, sir.
Yes.
Yes.
It's important to note, sir, and we've raised this issue previously with you on more than one occasion, that on July 21st, 2021, Mr. LaPrairie was indeed not your legal counsel. According to the Legal Professions Act of Northwest Territories, he was only given a restricted appearance certificate on August 6th, along with his associate, Ms. Sparrow. And if this is to be made an exhibit, it should be noted at the time that Mr. LaPrairie was not in concordance, nor in fact was Ms. Sparrow, in concordance with the Legal Professions Act of the Northwest Territories, which, as we've indicated previously, is not a signatory to the interprovincial protocol prohibiting Mr. LaPrairie and Ms. Sparrow from acting as legal counsel in the Northwest Territories matters. So to that extent, we take issue with the proposition contained in Mr. LaPrairie's letter and in his submissions in support of having this exhibit entered as, I believe, exhibit number 5, that he was in fact legal counsel. He simply could not be, in law, your legal counsel until August 6th.
Mr. Barclay, as you well know, this has been the subject of multiple letters written to you by Mr. Cooper and allegedly, I'm sorry, Mr. Barclay, should I? And as you know, it is allegedly a complaint made against myself and Ms. Sparrow and before the Law Society. It's something you've already ruled on that you will not deal with. But go ahead, Mr. Barclay.
The matter is before the Law Society. I don't want to take judicial notice of what they'll likely do, but it really has no effect at all until the Law Society deals with it, so I'm going to allow the exhibits to go in.
Exhibit 5, then?
And I did rule on that quite a number of times, Mr. Cooper, when you raised it before.
Sir,
that's Exhibit 5.
Sir, if I may,
Now, exhibit number 6, I propose that
in response to that additional piece of information, it may be that you ruled that you couldn't deal with the question in the terms of a conflict or bias, but this is an objection with respect to statements made in a letter and viva voce by Mr. LaPrairie purporting status that he didn't have. Now, your rulings with respect
that's not necessarily accurate, Mr. Cooper, because the matter is before the Law Society, and if it was somebody had dropped the football at the Law Society and there's somebody on holidays and there was a few days delay, they'll have to deal with it. In the meantime, Mr. LaPrairie is my counsel, and any documents that he has signed, I'm going to accept into exhibits.
I pose next, Mr. Barclay, exhibit number 6, and this is your letter of appointment as sole adjudicator, dated June the 28th, 2021, signed by Frederick Blake, Jr., Speaker. And I will just read briefly from it. Paragraph, the Northwest Territories Legislative Assembly Board of Management has recommended to me your appointment as sole adjudicator pursuant to Section 102(3) of the Legislative Assembly and Executive Council Act. I have accepted that recommendation and hereby appoint you as sole adjudicator in an inquiry into a complaint made by Rylund Johnson, the member of Yellowknife Northridge, alleging that Mr. Steve Norn, the member for duly, breached the member's code of conduct. The Integrity Commissioner for the Northwest Territories, David Jones, QC, has investigated the complaint and directed that an inquiry be held before a sole adjudicator. A copy of Mr. Jones's report is included with this letter of appointment.
Be so marked.
I tender then that letter of June 28, 2021 as Exhibit 6.
Yes. It'll be marked as Exhibit 6.
Next, number 7, I tender for marking as an exhibit, document number 7, a letter of July 8, 2021 from Frederick Blake Jr., Speaker of the Northwest Territories Legislative Assembly, addressed to you, Mr. Barclay, and it reads, terms of reference. Further to my correspondence of June 28, 2021, appointing you as sole adjudicator into Mr. Rylund Johnson's complaint against Mr. Steve Norn, please find attached terms of reference for your inquiry. Thank you again. I look forward to receipt of your report. Signed, Philip Blake Jr. Attached to it, Mr. Barclay, and so critical to these proceedings are the terms of reference that you have, and with your agreement, I would read those into the record.
And they're critical to the whole hearing, so I think it's important to read them in.
Terms of reference. Number 1. The sole adjudicator, the Honourable Ronald L. Barclay, QC, as appointed on June 28, 2021 by Frederick Blake Jr., Speaker of the Northwest Territories Legislative Assembly, on the recommendation of the Northwest Territories Legislative Assembly Board of Management, shall inquire into a complaint made by Rylund Johnson, a member of Yellowknife North, as to whether Stephen Norn, bracket, Mr. Norn, end of bracket, member of the Legislative Assembly for Tuna-Willaday, performed his duties of office and arranged his personal affairs as required by the Legislative Assembly and Executive Council Act, the Act, and or the following sections of the member's code of conduct, code established by the Act, including the guide relating thereto. Section 2, members must act lawfully and in a manner that will withstand the closest public scrutiny, upholding the integrity and honor of the Legislative Assembly and its members. Members shall ensure their conduct does not bring the integrity of their office or of the Legislative Assembly into disrepute. Section 4, members must carry out their official duties objectively and without consideration of personal or financial interests, and must arrange their personal affairs as to maintain the trust and confidence of the public. Section 8, the code is not designed to be exhaustive, and there will be occasions on which the members will find it necessary to adopt more stringent standards of conduct in order to protect the public interest and to enhance public confidence and trust. Paragraph. In that it is alleged that Mr. Norn in April 2021, A, breached Section 2A and D of the Public Health Order, COVID-19 travel restrictions and self-isolation protocol as amended December 1st, 2020, the order. B, failed to self-isolate in compliance with the self-isolation plan he filed, bracket, self-isolation plan, end of bracket. C, misled the public regarding his compliance with the public health order and or self-isolation plan. Number 2, the sole adjudicator shall also inquire into the reasons why Mr. Norn left the Northwest Territories in April 2021, where he went and what he did during the trip to determine whether taking the trip would constitute a breach of the Act and or code. Number 3, the sole adjudicator is to inquire into and report his findings on such other related matters which the sole adjudicator considers relevant to the inquiry. 4, The sole adjudicator shall, after conducting the inquiry, submit a disposition report with reasons as required by the provisions of Section 106 of the Act. Those are the terms of reference, and I asked Mr. Barclay that the letter to you of July 8, 2021, and the terms of reference be marked as Exhibit 7. May it be
So marked.
Exhibit 8. Exhibit 8 is your engagement of me as counsel for the inquiry, a letter of July 14th, 2021, addressed to me, and it reads, by approval of the Honourable Frederick Blake, Jr., Speaker of the Northwest Territories Legislative Assembly, dated June 28, 2021, I have been appointed to act as sole adjudicator for the inquiry pursuant to the provisions of 103(2) of the Legislative Assembly and Executive Council Act. The terms of reference for the inquiry were established on July 8, 2021, and are attached hereto. In accordance with my power under Section 105(1)(b) of the Act and pursuant to the provisions of Section 10 of the Public Inquiries Act, I hereby engage you as legal counsel to the inquiry. I understand you will be assisted by Ms. Shauna Sparrow. I hereby designate you and/or Ms. Sparrow as a person to receive all documents and property required to be produced under subsection 4, sub 2 of the Public Inquiries Act for the purpose of the inquiry, signed the Honourable Rylund L. Barclay, dated July 14, 2021. I ask that be marked as the next exhibit.
It'll be marked as Exhibit 8.
Next, as I've mentioned in my introductory comment, there are rules of procedure and practice that you have promulgated, which have been provided to counsel for Mr. Norn as they have been amended. The latest amended version of those rules, which I will not read, is the amendment that took place on the 20th of September 2021. I propose that the second amended rules of procedure and practice for this inquiry be received as Exhibit 9.
So marked as Exhibit 9.
One moment, Mr. Barclay. Where is this? Oh, yes, I've got that. Thank you. Sorry for the interruption. Exhibit 10. Exhibit 10, as I said in my introductory comments, we would be looking at, which is the notice of hearing. And the notice of hearing gives notice to all persons that you did on August the 3rd, 2021, appoint this day, the 10 a.m. on Monday, October 4th, 2021, as the time and place of the hearing of this matter at the Committee Room A of the Legislative Assembly in Yellowknife. And this notice of hearing also provided that the following: rights of interested persons to be heard. Paragraph. Take notice that any person who claims to have a substantial and direct interest in the subject matter of the inquiry can apply to the sole adjudicator to have an opportunity during the inquiry to give evidence and to call and examine or cross-examine witnesses personally or by their counsel on evidence relevant to their interests. The sole adjudicator will determine if any person will be heard, and if so, the manner and extent of that participation. Applicants who claim to be heard must complete and submit the attached application by September 14th, 2021 at 4 p.m. Dated the City of Regina, Saskatchewan, the 3rd day of August, 2021. Signed by you, Mr. Barclay. Attached to it were the terms of reference and an application that parties could fill in if they wish to claim standing at the hearing and being heard. This was advertised on August 23rd in the News North and on August 27th, 2021 in Quillion. And I know I'm mispronouncing that. I'll spell it L''AQUILON. Both of those publications published this notice of hearing. The notice of hearing was also placed on the Legislative Assembly website and social media pages. The deadline to apply for intervener status was September the 14th, 2021 by notifying our office, and we received no notice of anyone wishing to intervene. I ask that this notice of hearing be marked as Exhibit 10 in these proceedings.
It'll be so marked as Exhibit 10.
Exhibit number 11, which my friends which is a lengthy document, which is the Members' Handbook of the Northwest Territories Legislative Assembly, Members' Handbook Policies and Procedures, which is a voluminous document, but it contains the sections which Mr. Norn is alleged to have breached. I ask that this entire publication, which includes the relevant sections, be marked as the next Exhibit 11.
It'll be marked as Exhibit 11, the Public Health Order.
Oh, this is the Members' Handbook.
Is it the handbook?
Yes.
Sorry. Okay.
Members' Handbook, Northwest Territories.
Oh,
No, I think it's 11.
11?
11,
Okay.
it's 11.
It'll be marked as Exhibit 11.
Next, and we now come to some evidence, and this is the first piece of evidence, the affidavit of Jacob Pasco, sworn August 20, 2021, in which Mr. Pasco attaches excerpts of statements made by Mr. Steve Norn to the legislature of the Northwest Territories in 2021 and 2021 re-COVID that were taken directly from Hansard. And I would submit this affidavit and ask that it be marked and entered as evidence.
It'll be so marked.
Sir, before it is so
Yes,
marked,
Mr. Cooper.
I must strenuously object. We received communication and so much over the last few days, within the last 24 hours, I believe, in which we were told by Mr. LaPrairie that the affidavit material of Jacob Pasco and the affidavit material of Dr. Andy Deli-Pizzi would in fact not be submitted. And so it comes as a complete surprise.
Yep. The communication was that the affidavit that related to the video, which is at tab 15, statements gathered from the Standing Committee on Accountability and Oversight's public briefings, that affidavit would not be entered. That was an hour-long video.
And it'll not be going in. That's Exhibit 15 in the...
That's the one I was referring to, Mr. Cooper.
and that's not going in.
Sir, we've also indicated to my
Do you have
friend...
this?
I'm sorry, sir.
Pardon?
We also indicated to my friend that, and we've been consistent and timely, that in the case of exhibits that were intended to be entered without cross-examination, as indicated in Mr. LaPrairie's letter of September 29, that we are insisting upon cross-examination in each instance. So whichever affidavits are intended to be entered by exhibit, we're seeking to cross-examine. There are many questions to be posed of Mr. Pasco. There are many, many questions to be asked of the next witness that we understand may be tendering evidence by affidavit in a proposed uncross-examined form. But Mr. Pasco has put together considerable material, whether it's some or all of it that's going to be tendered, that should bear examination by cross-examination. It's important evidence that you as a sole adjudicator are going to be considering in your decision. The purportedly complete contents, the relevant contents of Hansard put together by a summer student are going to be, if my friend has his way, simply submitted, not subject to cross-examination, and yet by any measure are going to be an important component in your deliberations. And we insist that we be entitled to cross-examine Mr. Pasco, or that the affidavit evidence in its entirety not be submitted at all.
Mr. LaPrairie?
Yes, Mr. Barclay. First of all, these are nothing more than Hansard excerpts, excerpts from the Hansard of the Northwest Territories.
Are they a matter of public record?
Yes, they are a matter of public record. They were also provided to Mr. Norn during his recent examination, and he undertook to advise if there were any inaccuracies. He has never advised me of any inaccuracies. These are matters simply of public record, and it would be improper to allow cross-examination on matters of public record, and there are authorities to that effect.
Sir, if we can refer to...
Please let me finish, Mr. Cooper.
Mr. Cooper, let Mr. LaPrairie finish, and then I'll call on you. But the issue is if the information is uncontroverted and is a matter of public record, then the case authorities generally don't allow cross-examination.
Yes, the authorities I was going to refer you to, Mr. Barclay, include the authorities from Saskatchewan, Mr. Justice Ball's decision. Oh, yes, there it is. Justice Ball's decision in the Crown and Hand and Pub case, Saskatchewan case 213-924, was Mr. Justice Ball holds that paragraph 10, leave to cross-examine on affidavits filed in support of an application is a discretionary matter. The applicant must demonstrate that cross-examination will assist in resolving the issue before the court and will not result in an injustice. Leave will generally be permitted where there is contradictory evidence or where there is sincere legitimate need for clarification or information. These principles apply to cross-examination all affidavits filed, including applications for certification. And then in paragraph 14, by and large, the affidavits filed by the consortium in respect to this application for carriage and stay orders and by the defendants in support of their application for a stay deal with the progress of credit card class action litigation in this and other jurisdictions. The information is uncontroverted and a matter of public record. Mr. Merchant was unable to explain how it might assist the court to have him cross-examined on what is not in dispute. And also the Ontario decision in Frank Mapletop and Christopher J. Service, a decision dated January 29th, 2008. Had the relevant paragraph highlighted, but it's not appearing on my copy. Okay. Paragraph 11. Generally speaking, the decision concerning who should swear an affidavit is a legitimate tactical decision because the deponent may be subject to cross-examination. I pause to observe, however, that both the right of cross-examination and the choice of a deponent are open to abuse. It would be improper to have an affidavit sworn by second hand just to protect the person with important knowledge from cross-examination on a contentious issue. It is equally improper to engage in unnecessary cross-examination of a deponent who is swearing to facts that are not in dispute. So, Mr. Barclay, based on those authorities and on the authorities that this is a matter not in dispute and which Mr. Norn had ample opportunity to advise me of any inaccuracies as I examined him on September 22nd, and he is not so advised of any inaccuracies. I ask that this affidavit be marked.
Mr. Cooper, do you have any further submissions? It seems pretty clear from the case authorities that the information is uncontradicted. It's a matter of public record. How could the cross-examination assist me at all?
Well, certainly, sir. First of all, we don't concur that it's a foregone conclusion. Your own rules, if I may, specifically provides discretion for you to consider evidence by way of affidavit if it relates to matters of public information or record and is not acceptable to the sole adjudicator. May is permissive, it doesn't say shall. And it is found to be acceptable by the sole adjudicator, implying the proper application of discretion on your part. So it's not a foregone conclusion by any stretch of any legal imagination. And in particular, when one reads the affidavits of Mr. Pascoe, it's quite clear, less so at tab 12, purported exhibit 12, but certainly clearly in the exhibit which is contained at tab 13, that the student was given a fair degree of discretion. The fact that it's a public record is not the be-all and end-all. It's not determinative or conclusive, but rather this purports to be a relevant compilation of evidence that presumably you will consider in your deliberations. Now, what's interesting...
You have access to that document, don't you, the answer?
Every member of the public has access to answer. There's no question.
Exactly.
But the exercise of discretion by a summer student operating under Mr. LaPrairie and presumably Ms. Sparrow's direction is quite clear in the compilation of this material. So that we see on the exhibit sworn the 20th of August, 2021, tab 13, putative exhibit 13, Mr. LaPrairie informed me to only heed statements in assembly meetings where Mr. Norn is reported as being present, as well as to gather all responses of Mr. Norn's questions as to COVID self-isolation rules. And then paragraph 14 goes into further detail. So if Mr. LaPrairie wants the benefit of being able to rely on compilations, it's not enough to simply say, do you have any objections? And we've objected to all of the material that is purported to be submitted without the right of cross-examination. It's sufficient in our submission to grant us the ability to cross-examine this summer student on how he exercised his discretion. And I might say, sir, to whom did he speak at the Legislative Assembly? How did he access this material? How did he process it? How did he report back to Mr. LaPrairie and Ms. Sparrow? If he is purporting to submit information of this nature, a compilation of public material, certainly there should be a right to cross-examine. I'm not purporting that the cross-examination will be lengthy or deep, depending partially on the answers that Mr. Pascoe may actually submit. But in the place of viva voce evidence, if this sort of affidavit is submitted into evidence uncontested, then it's just another hit on the integrity and the reliability, the fairness and the objectivity of a process that we say has suffered from those maladies almost from the start. From the moment we got a letter from a non-member of the Law Society of Northwest Territories, up to the fact that we got an affidavit today that is purported to be relied upon this week. And sir, we say that Mr. Norn has the right to cross-examine this particular individual.
Anything further you want to
Nothing
add?
further.
Well, it seems to me, Mr. Cooper, that the law is, I can't see, if there was any prejudice at all, I would permit you in a moment to cross-examine, but we're dealing with the Hansard, and all the law students said, this is the Hansard, you've got access to it. You were given an opportunity to see if you had any objections, and there was never any objections today. But I'm really bound by these case authorities. One of my former colleagues in the Saskatchewan Court of Queen's Bench said, where the information is uncontroverted and a matter of public record, I really can't see how it would assist me at all, and I'm not going to allow it.
I tender as Exhibit 12 the affidavit of Mr. Pascoe dated August 20th, 21, re-Hansard excerpts of Mr. Norn addressing the legislature of the Northwest Territories re-COVID as Exhibit 12.
It'll be so marked.
Similarly, I tender Mr. Pascoe's affidavit sworn August 2021, re-Hansard excerpts of members of the Northwest Territories legislature on the issue of COVID-19 in the presence of Mr. Norn. As the next exhibit.
That'll be so marked.
13. Next, the affidavit that appears at tab 14, which is a transcription and a Facebook video of a public service announcement made by Mr. Norn on April the 3rd, 2020. And this was taken from Mr. Norn's Facebook video site. Attached to the affidavit is a transcription of what Mr. Norn says, and we also have the video which we'd like to play of his comments on April the 3rd, 2020 regarding matters relevant to the terms of reference.
Go ahead.
I'd ask that that video be queued up and played now.
How long is the video?
3 minutes.
Is this the video of Mr. Norn speaking?
Yes, in Facebook.
3rd, 2020. And for those of you who don't know me, my name is Steve Norn. I'm the MLA for Tuna-Willada in S.N.W.T. And as many of have heard, there were reports of a case of COVID-19 in my home community of Denis-Nouquin. I'd like to let everybody know that this report is true. And the said patient is now recovering at the Stanton Territorial Hospital in Yellowknife. And with this news, I want to say everybody, do not panic. It's important to continue to practice safe hygiene practices, social, physical distancing, any instructions from the Chief Public Health Office, Dr. Condola and her staff, your physician, doctors, nurses, public health nurse, local health nurse. These are unprecedented times that we're all experiencing. But through all this, we went through these scourges before as a community, and we got through it as a community because we worked together. And this presents a perfect opportunity to do that. And I fully support all measures that my community is taking right now in Denis-Nouquin to protect themselves. And I'm hoping that we work with each other as with the DKFN, with the Métis Local, with the JWT, and of course my office as well. And when we work together, we will get through this. And it's going to take discipline and patience above all else. This COVID-19 is no joke. It is bigger than politics. It doesn't see through family lines or social status. It infects indiscriminately, and we need to treat it with respect. And people are still not getting the message across. And so, effective immediately, I'm going to be lobbying very hard to see that there are liquor restrictions to limit the amount of alcohol being sold in the Northwest Territories, and I'll work closely with the Minister of Justice on that matter. We still, there's still rumors of partying happening, gatherings. Please, 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 do not do this. You're putting people's health at risk. If you have an isolation plan, please follow it religiously. Listen to it. They're there for a reason. They're there to protect us. And again, this is the time of year where we normally get together as carnival season, where we have our dog races, our talent shows, outdoor events, and we're getting out. We're in close proximity with each other. We're hugging, shaking hands, and right now this whole experience is going against that grain as Northerners. I ask again that we be patient, and we'll get through this together. And above all else, watch each other, look after each other. I noticed some social media posts already about this. I ask that everyone be kind and patient with each other. Nothing is going to be gained through this through bickering and petty arguments. And this is going to take cooperation and teamwork with each other. And I ask that of all of us. And be patient with our medical staff. They're being bogged down right now, and we ask that we be patient with them. And all our frontline staff for that matter. And with that, I want everybody to just spread the message out there to look after each other, use common sense, be respectful, and if anybody has any questions, you can reach me via email at steve_norn@nt.sw.ca. Good afternoon, everybody.
Did I read the transcript? 5 to 10 minutes. No. Okay. Well, we've heard that to the affidavit of Mr. Pascoe of August 20th, attaching the transcription and the video, which we've now played. I ask that Mr. Pascoe's affidavit and the exhibits be marked as Exhibit 14.
Will be so marked.
Next, I wish to inform you, Mr. Barclay, as I've informed my learned friend, Mr. Cooper, that we had at this juncture proposed to mark and the affidavit of Jacob Pascoe, sworn August 26, 2021, with a compilation of video from Mr. Norn's appearance and chairmanship of the Standing Committee on Accountability and Oversight. Mr. Cooper has made me aware of his strenuous objection to the same, and I have decided that in the interest of time, because it's a 1 hour video, and in the interest of expediting the proceedings, that I would not propose to enter that as an exhibit.
Thank you.
So Exhibit 15 will not be tendered.
15
is not tendered. So under tab 16, I now tender Exhibit 15. Here's under tab 16 in your exhibit book. It's the affidavit of Jacob Pascoe regarding the incidence of COVID-19 in Grand Prairie, Alberta during the relevant periods of time of April the 1st to the 4th. On Exhibit A, he has compiled from publicly available information the incidence of active cases in Grand Prairie during April 1st to the 4th, 2021, being respectively on April the 1st, 335 active cases, on April the 2nd, 353, on April the 3rd, 361, on April the 4th, 378 cases. And as Mr. Pascoe indicates in his affidavit, this is directly from the Alberta government's website. Tender that as the next exhibit will be Exhibit 15, appearing under tab 16 in the exhibit book.
So marked as Exhibit 15.
And appearing at tab 17, and as Mr. Cooper has advised me and requested the opportunity to cross-examine Dr. Andy Delapizzi on an affidavit dated September 15th, 2021, and to expedite these proceedings, I am not submitting for evidence this affidavit of public record that Dr. Delapizzi has sworn. I will not be submitting this evidence at this time.
Have you advised Mr. Cooper before? Or?
Yes, I have. And I wonder if we could now take a break, Mr. Mayor. Yes.
We'll take a break for 15 minutes.
Okay, it is now 3:18, so we'll come back at 3:30. 3:30, Ms. Anderson?
Sir?
Okay, adjourn. So we're back on the record. Mr. Barclay, I advised you that Mr. Cooper had approached me about some matters of confidence that he wanted to address you in camera regarding how these matters of evidence will be handled. And I told him that you would make yourself available for such a discussion this afternoon, and I would propose that we do that by a Teams meeting right now, Mr. Cooper, if that's satisfactory to you.
Mr. Cooper, we're quite prepared to accommodate you in your request about an in-camera discussion. And this may be a good opportunity to do it. We're right up to date on our schedule, and we've got some time.
Are there any other, just as a procedural matter, are there any other exhibits that you're purporting to tender, Mr. LaPrairie?
No, I'm right up to date. We're now ready for the evidence of Ollie Williams.
Okay, which is a matter which is
It's scheduled for 9:30 tomorrow morning.
Okay. Certainly, sure, that makes most sense, yes. So we're done with the public session today?
Yes, and wondering if you wish to engage in that discussion, flagged for me by correspondence of date I cannot remember.
There is the ongoing matter of how to deal with public versus private information, particularly of those that are not specifically involved, but we also have two matters that need to be dealt with as preliminary matters that can be dealt with today or tomorrow morning, but certainly must be dealt with before the first of the evidence itself is tendered, other than presumably that which is considered uncontested and is simply already entered as an exhibit. So I'm in your hands, Mr. Adjudicator, as to when you'd like to hear those two matters. There are the matters of subpoenas of additional witnesses, but also dealing with the matter of timing and adjournments.
The first issue is arguments over subpoenas. What is the second one?
An adjournment, sir.
An adjournment?
Yes, sir. I will not, I assure you, sir, be making the same arguments that have been heard and rejected previously. There are new sets of circumstances not connected with anything that we've discussed thus far that need to be considered in terms of whether the adjudication can continue as scheduled this week. So those are the two.
Well, it seems to me, Mr. Cooper, that this is the proper time to do it, and I'm certainly ready to hear you. Would you like to proceed now on those two issues? Which one do you want to deal with first?
I guess it makes the most sense to deal with the adjournment, because if it's granted, then the subpoena's application may or may not be relevant and timely. And if that's agreeable, sir, I would propose to deal first of all with our application to have the adjudication adjourned. Is that agreeable, sir?
This is the first I've heard of this, Mr. Barclay.
Well, I think we should hear from Mr. Cooper, and you go ahead, Mr. Cooper, on the issue of potential adjournment. We'll hear you, and then we'll deal.
Thank you, sir. May I proceed then?
Mr. Barclay, he asks if he may proceed.
You may proceed, Mr. Cooper.
Okay, thank you, sir. First of all, sir, I certainly take some umbrage at the suggestion that this is the first that my friend Mr. LaPrairie has heard in terms of our request for an adjournment, because consistent through the time that he has been your counsel, we have indicated that this feels like nothing more than a rush to judgment. We have specifically said that there is a suspicious intent, insistent intent to have this matter heard this week. Now, we've suggested adjournments on a variety of bases that you, Mr. Adjudicator, we say unfairly, have described as delay tactics. It's not a delay tactic when we are being pummeled by information nonstop for 2 months. Sir, on Friday, we received 680 pages, excluding the video and audio components And it is not enough for Mr. LaPrairie to say in his defense for this belated disclosure that you've got it all, you've had it all. That's not true, but we'll get to that in a moment. In fact, we've had almost no time to go through the material that was provided, much of which has been made an exhibit today. How are we to know that what has been submitted on Friday, just a few days ago, I'm not talking a week ago or 2 weeks ago, on Friday, we have to go through the material to determine what we have and what we hadn't seen before. On top of all of that, until 2 weeks ago, we didn't have the one thing that is mandated by legislation and is referred to in your rules of procedure as it relates to this adjudication. And that's the notice that is required of the potential for adverse findings or findings of misconduct. 2 weeks ago, sir, Mr. LaPrairie is quick to point out that this has been going on for some time, including 3 weeks while he was not even legally entitled to be involved. But since the time, August 6th, that he has lawfully been entitled to be your legal representative, we have been getting material after material. And yet, the critical document, the one document that you are bound to issue as the adjudicator, under this umbrella of parliamentary privilege, you're obliged to do almost nothing and entitled to do almost anything. But you must give the notice. So the notice shows up 2 weeks ago. Can you imagine facing these serious allegations with only 2 weeks to prepare? Now, importantly, yesterday, Sunday, we got an updated notice with 2 more allegations contained in that mandatory document. And the mandated document, sir, I am quick to note, must be given on reasonable notice. Is 2 weeks with this voluminous material, with these incredibly important allegations that can lead to nothing less than the removal of a democratically elected representative over any objection and without the involvement of any of his constituents. Truly the only people that he can be said in a democracy to work for. We are being forced to deal with matters in hours. Our previous application with respect to subpoenas and the related matters, at one point we had literally 24 hours to respond. We have been receiving material on a regular basis without any ability to anticipate its arrival. This morning, sir, I don't know how well this comes across, we got this. This is a new affidavit. We got this. And yet we're expected to be prepared to meet the case. It's expected that Mr. LaPrairie can look at my client and say, you know the case you need to meet. You've been given reasonable time to prepare. We received affidavit material on Friday afternoon with substantial new evidence that actually resulted in the Sunday delivery of the new mandatory notice of potential findings of misconduct. The problem, sir, is twofold. First of all, we can't possibly understand the case that we have to meet until we have all of the material. That's true in civil litigation, it's true in administrative law, and it's true in criminal procedure. And unless and until you know you have everything, all of the evidence, it is impossible to understand the case against you. It is impossible, in administrative terms, to prepare based on the allegations. We literally have no idea when we're going to get more material. I was absolutely shocked to get this document here. 52 pages, I think it is, or more, this morning. Now, somebody's going to say, well, you kind of knew that was coming. We didn't know. We don't know what's coming. I expect we're probably going to see something tomorrow and probably the next day. So let me give you some idea as well. We actually sat down and under the learned keyboard of our paralegal, Jamie Grift, we did a chronological summary of when we received everything. And I'm not even going to look at the first stuff that we got back in July. before Mr. LaPrairie was a member, or even the beginning of August when a similar status occurred. But even if I start September 20th, not even 3 weeks ago, we're getting an affidavit of Dr. Andy Delipizzi, an affidavit that until yesterday, the day before, maybe even today, Mr. LaPrairie was intending to submit without the power of cross-examination, and very kindly has now recognized that maybe we either should have the right to cross-examine or at least shouldn't have to deal with an affidavit upon which cross-examination was not granted. We received a witness summary, sir, on September 24th, not even 2 weeks ago, from Stephanie Gilbert, who is a critical witness by any measure. And Stephanie Gilbert is one of the witnesses that Mr. LaPrairie specifically says that he intends to rely upon in submission of materials to you. On September 27th, we received not the affidavit of Brian Thagard, I apologize if I mispronounced his surname, the draft affidavit. On September 27th, we received that, barely a week ago. On September 28th, we received a transcript of Steve Norn from his September 22nd interview with Mr. LaPrairie. Shockingly, September 29th, just a few days ago, we received the equally important transcript of Natasha Schwinn, one of the people directly involved in the factual matters that bring us here today. Later that day, we received the transcript of Sue Ellen Dillabaugh, another individual that Mr. LaPrairie has indicated will be providing what presumably is critical evidence, because there are so many witnesses and he's pared it down to a number, 6 or 7. Critically, sir, only on that day, September 29th, Friday, Thursday of last week, whatever it was, did we receive the critical correspondence from Mr. LaPrairie, basically indicating what he was going to be doing. We didn't know which witnesses he was going to be calling. We didn't know the arrangements for the witnesses. We didn't know who he was purporting to give evidence only in affidavit form without cross-examination. It came as quite a shock that Mr. Delipizzi was going to be one of the people that was going to be tendering his evidence untested by cross-examination. Now, if that's not enough, October 1st, we get the transcript of the re-examination of Tricia Smith, who, as I submitted already, was the source. That transcript, as far as we can determine, was the source of 2 new charges against our client, 2 new allegations that he went out of the house and broke his self-isolation plan. Then on October 3rd, yesterday, we received the amended notice of potential findings of misconduct. In the circumstances, sir, no standard of fairness, no standard applicable to administrative hearings has been met that allows my client the basic rights of natural justice. And yes, sir, we understand that you're not bound by rules or precedent or evidence or generically fairness. But you have imputed to yourself, quite understandably and quite necessarily, the integrity of the process, the standards of fairness, impartiality, and objectivity. We aren't engaged in delay tactics, sir. The delays have all been caused by Mr. LaPrairie, and I'm not blaming him. It's the fact that the date of the hearing has been established as unmovable. Mr. LaPrairie's position on this, whether that's yours or Mr. LaPrairie's, is that it won't be moved. And the position seems to be bolstered by the fact that, yes, back in July 22nd, we received a letter from a not yet member of the Law Society of Northwest Territories indicating that the hearing would be happening on October 4th. And we didn't take objection, although we subsequently said, you could have asked us first. But that's fine. What happened is in the intervening several months, we didn't receive evidence in a timely fashion. Now, how do you deal with that? I posed this to senior colleagues of mine. They said, you obviously give an adjournment. You don't force people to defend themselves against serious allegations that could, in this case, as I've said, and it bears repeating, in the removal of Mr. Norn from his duly elected position. We've speculated, and there's never been an answer from Mr. LaPrairie himself or on your behalf as to why it is that having the matter dealt with this week must happen. There's one conclusion, to take the Sherlock Holmesian approach. When you've ruled out all other possibilities, and there's only one left, however unlikely, it must be the explanation. What is that explanation? There's a session happening in 10 days. That this date is politically motivated. That removes objectivity and it removes impartiality. And in our submission, sir, if the adjournment is not granted in light of the late and ongoing, never-ending, voluminous disclosure, that you as the adjudicator will be party to that defect. That Mr. LaPrairie, as you so carefully explained to us, is an extension of you. That means that this process, this inquiry, is now unable to proceed without being inherently, fatally full of flaws. My client still does not know from Mr. LaPrairie that the evidence is done. If we had asked him on Friday, I guess he knew this was coming on Sunday. There's more evidence, and there's actually Monday, we're still getting evidence. So it's virtually impossible for this application to proceed. And at the end, have a decision that anybody thinks is reliable. Because I can tell you, sir, we've been run off our feet for months trying to keep up with all of the evidence. You asked us, sir, well, answer, why didn't you go and do your own search? The real reason is we don't have the time. We are so busy dealing with the onslaught of material and trying to put together positions on matters that have been arising since July 22nd or 23rd, we simply don't have the time to do it. And that's exacerbated by the fact that we just never knew when this onslaught was going to end. This does not feel like an inquisition, an inquisitorial process, which is really what this is supposed to take the form of, but rather it feels like a prosecution. And I know, sir, that Mr. LaPrairie is not in the form of a prosecutor. I know that's not his role, but I have to tell you, sir, that the impression of my client and his counsel is that this is a prosecution, not an inquiry, the results of which are essentially, potentially the same. There's no delay tactics on our part, not at all. We've been responding in a timely fashion to what you described quite accurately, sir, as very complex matters of law. In our position, to allow this hearing to go on is to ensure that the results will be considered unreliable and unconscionable. And we all know, given your background and your status, that that is not the goal in this inquiry. We understand and we respect the fact that your findings will carry considerable weight because of the very background that you've provided to us. And it would seem to offend so much of what you, sir, represent based on your background to allow this inquiry to go ahead on the basis we say, because we've heard nothing else, that is politically expedient to get this done this week. I'm going to use one other piece of evidence to suggest that my conclusions are correct on behalf of my client. And that's the remarkably aggressive, some might say optimistic, schedule to deal with the evidence over the next 2 days. Now, first of all, we ask ourselves, how on earth, as experienced litigators, as many of us listening in and are present are you going to get through Holly Williams in an hour and a half? Linny Lamberink in 45 minutes. Dennis Marchiori, the man whose affidavit was delivered today, in 45 minutes. We've got 6 other witnesses, excluding any witnesses that you may allow by subpoena, and get all of that done very conveniently by the end of Wednesday, allowing presumably Thursday for submissions to ensure that we get this done in time for your decision to be delivered to the next session, which we say is precisely the goal. Not fairness, not objectivity, not impartiality, but in fact, let's get this done so we can push it into the next session. And we submit, sir, if there's even an appearance or a hint of that as being the real agenda, whether it is or not, and I think we as lawyers, the administrative field, understand that appearance is everything, that the appearance of a problem of this nature is as important as the actuality. And in our submission, sir, this is too important to my client's constituents. It's too important to people that believe in democracy and consensus government in the Northwest Territories for this to be a rush to judgment, because this is precedent setting. Other MLAs are watching. Other MLAs that probably can't meet the standard that's in the member's handbook as read into the exhibits and into the evidence by Mr. LaPrairie are watching. This precedent must be clean, it must be reliable, and to use your words from the rules, it must be fair, impartial, and objective. And you will not, we assert, achieve any of those goals if you insist on this headlong rush to judgment. We need more time to prepare. We're not trying to delay. We're simply asking for the reasonable time to digest what is now probably over 1,000 pages of material that we've had in some cases a mere few hours. And it is not unfair for my client, given what's at stake, both in terms of his future and reputation, but also the future and reputation of the democratic process in the Northwest Territories, which we say is under attack and has been for some time. You've rejected all of our applications and approaches with respect to going behind the purposes of the inquiry. Within the terms of reference, we say we are entitled and you are obliged, in fairness, to give us enough time to represent our client to the best of our abilities. Those are my submissions on that issue, sir.
Thank you very much, Mr. Cooper. I'm now going to call on Mr. LaPrairie to make his submissions.
Thank you, Mr. Barclay. I'll be brief, but to the point. The disclosure here to Mr. Cooper and Mr. Hallibaugh has been fulsome and timely, and it has been delivered as received, as obtained. Within days, hours of it being obtained, it was provided to my friend. The information that my friend says he has 680 pages of, it was all provided to him in advance on the dates that I'm going to mention in a second. He need but only have organized it and put it in proper order. We provided him with a compilation of all of the documents as a courtesy to show him the order in which it would be presented. But had he paid attention to the documents as received and processed them, he would be prepared and should be prepared. Instead, with respect, my friend engaged in a series of 19 pieces of correspondence to you through me, in which he made numerous allegations and requests for delay and review and a lengthy application which resulted in a judgment which you rendered, Mr. Barclay. Those 19 lengthy pieces of correspondence required 19 fulsome responses by our office on your behalf, And if there was any diversion from the preparation of the case, it lies squarely on my friend's shoulders for his 19 separate missiles of applications and correspondence which were, with respect, not directed at resolving this matter, but rather delaying the matter as much as possible and trying to throw a wrench into the proceedings. The documents that my friend received were received as follows, and I will file this document with you, Mr. Barclay. On July, and these are the dates, we had difficulty sometimes with my friend acknowledging receipt of things. We had to remind him repeatedly that when we send you things, you need to respond. And it became much better when he got his paralegal involved, and we did get receipt. But let me start with my appointment on June 28th. It was sent on July 15th, acknowledged on July 28th. The rules of practice was first sent July 15th, 2021, acknowledged July 28th. The letter of engagement was sent July 15th, acknowledged July 28th. The terms of reference sent July 15th, acknowledged July 28th. The subpoena to produce documents and testify sent July 22nd, acknowledged August 4th, and with an affidavit of service of Mr. Norn of August 11th. Documents provided by Mr. Jones were sent to my friend. Those were introduced just this morning. You heard me introduce them. They were sent on July the 23rd, acknowledged on July 28th. Documents provided by subpoena from Mr. Rylund, that is the Legislative Assembly Control Register, the Legislative Daily Security Report, surveillance video sent July 23rd, acknowledged August 4th. The surveillance video from the Assembly sent July 23rd and acknowledged July 12th, sent July 12th, acknowledged July 23rd, pardon me. The oath of office and allegiance of Mr. Norn sent July 23rd, acknowledged August 4th. The notice of hearing sent August 3rd, acknowledged August 4th. The resolution, number 23-17, sent August 3rd with cover letter not acknowledged. Documents from Mr. Russell Newdorf sent August 5th, 2021. Not acknowledged. First amended rules of practice and procedure sent August 13th, 2021. Affidavit of Jake Pasco, re-background of COVID-19 in Grand Prairie, sent August 20th, acknowledged August 20th. Affidavit of Jacob Pasco, re-Hansard excerpt, sent August 20th, acknowledged August 20th. Affidavit of Jacob Pasco, re-Hansard excerpts of Mr. Norn, sworn August 20th, sent August 20th, acknowledged August 20th. Affidavit of Jacob Pasco, retranscription of Facebook video, sent August 20th, acknowledged August 20th. April 2nd, 2020, Facebook PSA from public service announcement from Mr. Steve Norn, sent August 20th, acknowledged August 20th. Affidavit of Jacob Pasco, re-standing committee, sent September 9th, acknowledged September 9th. Exhibit B to the affidavit, the edited video from Mr. Pasco had to his affidavit, which we have not entered, sent it September 9th. Download receipt, received September 9th. Witness statement from Robert Brain, sent September 16th, acknowledged September 16th. Statutory declaration of Linny Lamberink, sent September 8th, acknowledged September 8th. Affidavit of Ollie Williams, affirmed September 10th, sent September 10th, not acknowledged. Research memo concerning Rule 107, sent September 13th, 2021, not acknowledged. COVID-19 report and exposure investigation form, sent September 13th, acknowledged September 14th. Decision of the Sole Adjudicator, sent September 13th. Social media post by Mr. Norn, sent September 14th, acknowledged September 14th. Screenshot of Mr. Norn's phone, sent September 15th, acknowledged September 15th. Affidavit of Dennis Macchiori, sent September 16th, acknowledged September 16th. Transcript of the August 31st, 2021 interview of Tricia Smith, sent September 7th, 2021, acknowledged September 7th, 2021. Subpoena to attend interview, sent September 16th, acknowledged September 16th. Revised subpoena to attend interview, sent September 20th, 2021. 33, affidavit of Andy Delapizzi, sworn September 15th, 2021, sent September 20th, acknowledged September 20th. Second amended rules of practice and procedure, sent September 20th, acknowledged September 27th. 35, day 14 symptom check document sent September 21, acknowledged September 21. First draft of potential findings of misconduct sent September 22nd, acknowledged September 27th, 5 days later. September 23rd, letter blended hearing sent September 23rd, 2021, not acknowledged. Witness summary of Stephanie Gilbert sent September 24th, acknowledged September 24th. Affidavit of Brian Thagard sent September 27th, acknowledged September 28th. Transcript interview of Steve Norn, September 28th, when we received it, acknowledged September 29th. S.N.W.T guide for traveler symptom check sent September 28th, acknowledged September 29th. Letter from 2FAM with correction to Tricia Smith interview sent September 29th, acknowledged September 29th. Transcript of Antisha Schwent sent September 29th. Transcript of Sue Ellen Dillabo sent September 29th. Transcript of Tricia Smith, October 1st, acknowledged October 1st. These documents, as and when they were received, and according to your rule 22, where practical in the best interest of facilitating an efficient, thorough, and fair process, counsel to the sole adjudicator will make best efforts to provide to witnesses and parties withstanding the following material prior to the testimony of a witness: a brief summary of the anticipated evidence, identification of any documents that will be referred to, and a copy of the transcript of any witness interviewed. With respect, Mr. Barclay, I submit this document to you. I asked my friend, Ms. Sparrow, to send our friends a copy of it. This demonstrates that as we received documentation in the preparation of this hearing, it was provided to my friend. Had he not been spending his time with respect on 19 excessively long letters of which he made numerous complaints, which I could not even begin to enumerate, he would have focused instead upon the material provided and be prepared to proceed. He also, as a courtesy, we provided last week a compilation book, which you have, the exhibit book, which does nothing but capture all the documents that we've been sending him over the course of the last several months, as I've enumerated to you. Now, and with respect to the one change to the testimony of Tricia Smith, she gave testimony on August 31st. On September the 28th, we were advised that there was a material change to that evidence. And we were advised by her counsel. And we immediately arranged for a further examination to determine what that clarification was. We forwarded on October 1st the re-examination of that witness, who provided further information that she had not given to us when we examined her on August 31st. We had no opportunity to have that information earlier. We provided her counsel's letter in which he explained the change to her testimony that she proposed. That was given to my friend as and when it arrived in our offices. So my friend has had timely disclosure of all of the documentation. He needed to have organized it properly in timely and not diverted his attention to the matters which he addressed you on. On the notice of misconduct, the notice of misconduct was provided to my friend as indicated in the list. This is a confidential document. This is nothing more than a compilation of all of the items which based upon the evidence as we get it, we provide a notice to Mr. Norn's counsel of matters that he needs to be aware of that could be the subject, and I emphasize, could be the subject of your findings of misconduct. These notices of misconduct, as contemplated by your rules, are amended as the information unfolds. The information provided to us by Tricia Smith in her re-examination, following her advice that she was changing her testimony in a material matter, resulted in a further amendment to that notice of misconduct, which we were not aware of until we had examined her. And therefore, we amended the notice of misconduct and provided. That notice of misconduct, as referred to in the rules and in the legislation, is something that I am as obligated as your counsel to revise and update as the evidence unfolds. And I've committed to do that, and I have done it in a timely and reasonable way. So with respect, my commitment to this process is only to organize it and present it to you in the logical, fair, and reasonable manner, which I believe that is being done before you. In my experience of 44 years of litigation, this is one of the most organized and well-presented, fulsome, and timely disclosure of documentation that I've ever encountered, whether it be in an inquiry or in the hundreds of civil cases I prosecuted before the courts of Saskatchewan, whether it be the Court of Queen's Bench, the Court of Appeal. And so with respect, there is no basis for the claim that one other matter, the affidavit of Dennis Marchiori, which we just provided, is nothing more than a document that was previously provided to my friend, but not in a sworn form. All it is, it might be a big document, but there's only about 2 pages relevant in this COVID-19 symptom check for travelers. The only 2 pages that are relevant, 2 or 3 pages that are relevant, relate to what occurs on a symptom day 14 check by Stats Canada. That's the only relevance to it. We didn't want to have only an extract. We gave him the entire document, which he's had before, in any event. But it only relates to a day 14 symptom check and what is expected of the Statistics Canada people who call a person on a day 14 check. That document was not in an affidavit form. It is now in an affidavit form. It doesn't take my friend by surprise, and it should certainly not form the basis of any request for an adjournment. Mr. Barclay, those are my submissions to you on the request for an adjournment.
Thank you very much, Mr. LaPrairie. Mr. Cooper, do you have a response to Mr. LaPrairie?
Sorry, sir, we didn't hit the mute button fast enough. Yes, by way of reply, perspective is everything. And timely disclosure is a matter of perspective. I'm not saying that Mr. LaPrairie and Ms. Sparrow were not timely, but the evidence wasn't timely. So from the perspective of the man accused of doing these things, the evidence was not timely. That's no fault of Mr. LaPrairie or Ms. Sparrow. That's just an occurrence. And in 33 years, not quite 44, of civil litigation and criminal litigation, I've never been presented with a case that I'm expected to litigate or defend or prosecute when the evidence is still coming the morning of the hearing. It's unprecedented in my humble 33 years. But most importantly, rather than defending his own behavior, which is really what Mr. LaPrairie is doing with respect to this application, in an objective, fair approach, you say, how has this affected Mr. Norn? Now, the affidavit this morning, I don't know what's in there, I haven't had time to look at it. I shouldn't have to be forced to look through the material to draw the conclusion that Mr. LaPrairie has, which is, it's only 2 pages. There's 2 problems with the timeliness approach. Timeliness must be perceived from the perspective of the person accused. We, as his counsel, cannot prepare his defense until we know all of the evidence. Mr. Norn cannot know the case against him until we have all of the evidence. And receiving the evidence, as we have really only over the last less than a month, other than the stuff that the summer student did, which came in August. The evidence has only been filtering to us since September 7th or thereabouts. And what we noticed, as I said previously in response to Mr. LaPrairie's timeliness argument, is that we just didn't know when it was going to stop. So how do we, as counsel defending Mr. Norn, prepare our case not knowing what's coming next? That's not a function of anything Mr. LaPrairie or his staff are doing wrong. But when he, as he just did in his submissions notes, that one of the principal witnesses, Tricia Smith, fundamentally changes two components of her evidence. It's important for two parts. Number one, it changed the allegations and the potential findings with respect to this individual, but it also changes our approach to cross-examination of Ms. Smith. We're preparing cross-examination on the basis of what she said before, not of what she said now, and now we have to readjust everything. Yes, we can do some things on the fly, but it offends the principle that we should understand the case and have time to prepare. So from Mr. LaPrairie's perspective, as your counsel, he was very timely. I don't doubt that he pushed all of the information out to us as quickly as it was available, as quickly as the transcripts were available, as quickly as the affidavits were sworn or the statutory declaration was sworn. But from the important, more relevant perspective of the person accused of these important matters, they weren't timely. It doesn't matter how many letters went back and forth between the parties. We are entitled to defend our client to the best of our abilities, regardless of the outcome of those efforts. So yes, we spent important time, and yes, you spent time preparing a response to our submissions. And that's fine. That's how litigation and administrative law works. But how it doesn't work, and what offends the basic principles that this inquiry says it stands for, we just haven't been given a reasonable opportunity to prepare. And I still, right now, have no idea why this matter has to go ahead this week, not next week or the week after. Never been explained. We've been asking this for at least 2 months. Why October 4th? It's not just that the adjournment is being denied, but why the insistence on this week, Mr. LaPrairie? Why this insistence on this week, Mr. Barclay? When we say we're still getting stuff, and you know, the attacks on our organization, it's gaslighting. Popular term these days, it's gaslighting. How many letters that we sent? It's gaslighting. I was going to get my staff to add them up on our end and say it's not working. It's gaslighting. What is important is that we just haven't had the information that we needed in a timely fashion through no fault of anyone. That's why adjournments are so regularly given, particularly when the date hasn't moved 1 hour from when it was originally set back in July. Had we known, had anybody known, that the evidence would still be coming in on the first day of the hearing, or on the day before, or 3 days before, we would have been protesting the date back then. When the date was set in July, we could not reasonably have anticipated, nor could anybody in our submission, that we'd still be getting evidence the Friday before. And in our submission, if the inquiry stands for anything, it has to allow us to prepare. This is not, as Mr. LaPrairie suggests, disorganized or untimely, or we're not doing our job, or we're spending too much time defending our client on things that he doesn't agree with. That's not what we're talking about. The simple fact is the evidence didn't make it to us in time for us to prepare. And we've been rushing around trying to do so, and then shaking our head here saying, oh, got another affidavit. Oh, got some more evidence. So we are now left with a position of really not knowing what the case is about. Wouldn't be surprised if we get something else later today. Maybe it'll be an amendment to the evidence. I don't know. Importantly, sir, not even knowing who the witnesses were going to be until a week ago. Less than a week ago, September 29th. That's important because if we don't know who the witnesses are going to be, we don't know how the evidence is going to be submitted by affidavit with or without cross-examination, we can't prepare. So it's not just one thing, and we're not casting blame. And we aren't guilty of delay tactics. We're guilty of defending our client against very serious charges on the basis that we have a right to do so as allowed by the system. And the system has worked. We made our submissions. You granted us the time that we needed. It was rushed. We got it done. You gave a decision. We're bound by that decision. But that doesn't change the fact that we still don't know if we have all the evidence. And it doesn't change the fact that the first piece of substantive evidence beyond matters of public record didn't get here until less than a month ago. And in our submission, if the adjournment is not granted, there is no chance that my client or the public can perceive this as a fair process, allowing my client to properly defend himself against serious charges with incredibly anti-democratic recommendations possible at the end. Every opportunity has to be given to my client to defend himself. We're not looking for the second or third or fourth adjournment. We're looking for one. And it is as well grounded as I've seen in many years of doing this. Those are my reply comments, sir.
Thank you very much, Mr. Cooper. What I'm going to do is consider your arguments, and I'm going to render a judgment on the adjournment at 9:30 tomorrow morning.
Okay, should we deal with the subpoenas?
Is there any reason, Mr. Cooper, that we can't deal with the subpoenas too?
Well,
some idea. Just let us know what you're contemplating and make my task a little easier.
Yes, there are, and I think to some degree we've already identified these individuals to Mr. LaPrairie.
You did in your letter, but I just want to make sure we're on the same song.
I think that was letter number 19. I believe that there were 3, and I'm sorry, sir, in my impassioned submissions, I misplaced the witnesses I was proposing to call. Here they are. Yes. We are seeking, and I'm not going to propose to get into the basis, although it's important to assure you, sir, we are not seeking subpoenas against some of the same people as have already been rejected for different reasons. We are looking for assurance that Dr. duly will be made available. He's somebody that can give important information on the creation, explanation, and promulgation of the COVID rules. This is incredibly important, and I'll give you one example. I'm going farther than I anticipated, but something to think about overnight is the 14 days. How does that calculate? And yes, there's different information online. So we certainly want him made available to us, at least for cross-examination. And similarly, Dr. Cami Candola, I understand that she is Dr. duly's superior. It will be important for us to understand her interpretation of that which our client is alleged to have breached. It will be important for you to understand what the Chief Public Medical Health Officer has to say about this. Now, frankly, it might go either way. We know that. But it's important for the public to know that you have heard from the top information about the COVID situation, orders, and self-isolation plans. We intend, upon being granted the privilege of her testimony, to cross-examine her on that issue. There's 2 others, actually, that we're looking for. Both Glenn Rutland and Sheila McPherson, but not, I assure you, sir, for anything in connection with the previous matter, which has already been dispensed with. But in fact, as the law clerk and as the acting clerk of the Legislative Assembly, these people, we understand, are responsible for educating MLAs. What did they know? How did they know it? How was it taught to them? How often was this updated? So again, sir, I'm going well beyond what I intended to do today, but it gives you something to think about in the meantime, maybe save some time as well. So we are looking for subpoenas with respect to Ms. McPherson as the law clerk of the Legislative Assembly, long-term law clerk, I might add, and Mr. Rutland, principally so that you are able to hear evidence about how a new first-term MLA would have been taught about the members' code of conduct, how to deal with crises, how to approach the media, how to deal with media inquiries. These are important given the evidence that has been tendered. So in the event that we are proceeding, those are the subpoenas that we'll be looking at.
Do any of the last 2 proposed witnesses that you've just articulated to me have any knowledge at all in respect to the terms of reference and the issues involved in the allegations of breach?
Absolutely, sir. We're saying that the member's handbook is in the material. It's, by my friend's apt description, it's quite voluminous. It's 98 pages long. There are components in there which form the core of your terms of reference. If you're asked to look into the conduct of my client as it suggests deviance from the code of conduct. So certainly my client is entitled to have you know what, if any, meaningful instruction they had with respect to compliance with the code. You'll certainly hear from Mr. Norn in that regard, but I think it's important that the Legislative Assembly is the source of the complaint. That caucus, consisting of all 19 members of the Legislative Assembly of the Northwest Territories, has submitted this complaint to its chair, Mr. Johnson. And so we think it's appropriate to hear evidence of those individuals who are responsible for educating MLAs about the very things that caucus suggests my client did wrong. And what policies, procedures, education, reporting, and other matters were used during the relevant time when my client was alleged to have done these things. So this is critical information. On the one front, with respect to the Public Health Department, Doctors Candola and Delipizzi, to understand their interpretation of that which it is said that our client breached. I can give you a very simple example there. Our client came back, for example, very late at night. Do you include that day? Or does it only start the next day? Is it by the hour, by the minute, by the day? Also, the interpretation of some of the information, but also how this information was promulgated, because there's going to be some discrepancy in the evidence as to when the release was supposed to occur and when it did. And that discrepancy will be somewhat explained, or maybe not, by the public health officers that I've set out. But on the other hand, what is happening internally in the Legislative Assembly? And my understanding is that Ms. McPherson and Mr. Rylund are supposed to be advisors, consultants, supporters, sources of information with respect to these things. So it'll be important to know how well they carried out their duties in supporting this new MLA, particularly in a time generally of crisis, being the pandemic, but specifically where he was obliged to leave the Northwest Territories. What assistance did they offer? What information? What approach did they make? What knowledge did they have? I'm not going to go into all of the areas of proposed cross-examination, but that gives you a good understanding of why this evidence will be important. Because it's not just Mr. Norn that's involved in this process. If the Legislative Assembly wants to rely on their 98-page handbook with a new MLA, it seems to me that there's some responsibility, some guidance, some advice that should and maybe was proffered to Mr. Norn and probably the other MLAs, but also it's important to understand how they get involved in a crisis. So how was Mr. Norn supposed to deal with these things? If he broke his self-isolation plan, for example, what from the Legislative Assembly perspective, Mr. Rutland and Ms. McPherson, what should he have done? Should he have approached them? Should they have approached him? So all of this goes to the question of, if there's a finding that he breached the protocol, what mitigative steps should he have taken, but also what mitigative steps should the Legislative Assembly have taken? They're not just...
What you're suggesting at this stage, with particularly the two proposed witnesses, depending on what I do, if I find the complaint is not founded, that's the end of it. But if I get into the recommendations, you feel that the evidence of Rutland and McPherson would be helpful. Is that fair?
Yes, sir. And I think it would be critical, because your recommendation, if there is a finding that my client did any of the things that he is alleged to have done. Your recommendation, as I understand it, can be more fulsome than just what to do with Norn. But even more importantly, it'll be important to understand the depth of the problem as it related to Mr. Norn in order for you to make a recommendation. You have a wide swath of opportunity. And it seems to me that for everyone's sake, not the least my client, but for everyone's sake, particularly your own, it'll be important to hear from the people that have the experience within the Legislative Assembly, which was in fact the source of the complaint in the first place.
Thank you very much. And tomorrow morning, the only decision I'm going to make is the one dealing with the adjournment, and you will have written reasons for that.
Thank you, sir.
May I raise now the matter which I thought we were going to address, and that is, well, I wonder, you indicated, Mr. Cooper, that you wanted to approach Mr. Barclay with respect to how you wanted certain confidential matters handled. I wonder, in the interest of time, if you could commit that to paper so that we could consider it.
I note to Mr. LaPrairie that we were scheduled until 5, so I don't think it's unreasonable for me to suggest that we go with Plan A before I got on to a much longer than intended submission on subpoenas. Might we still do that in the Zoom format?
We could go to Teams format if you want, Ms. Barclay. Okay, we'll is that then what I'm proposing, Mr. Barclay, is that we adjourn till 9:30 tomorrow morning. And in the meantime, we'll have an in-camera meeting with you via Teams platform. And so that will end today's proceedings, if that please you, Mr. Barclay.
I'm in agreement with the suggestion, Mr.
Thank you, sir.
Okay, then, Ms. McPherson, we would stand adjourned.
What, Mr.
Ms. Anderson.
Ms. Anderson, you're going to have to change your name.
Yeah, for some reason, Sheila, I must apologize to you again. Sheila Anderson. Ms. Anderson, we'll stand adjourned.
McPherson. This matter stands adjourned until tomorrow morning at 9:30.
Thank you.
Thank you.